service virtual workshop. It's now live streaming and Facebook Live, and we just need for it to record. Has the recording started yet, Miss Deanna? All right, good afternoon, everyone. My name is Myra Hippolyte, and we are in the process. Thank you. We are recording. Good afternoon, everyone. This is the month of service virtual workshop. It's all about giving you free information about different stressors in your life. We have different workshops on Tuesdays, Wednesdays, and Thursdays. And we have a first-time home buyer class on Saturday, once a month on Saturday. So if you're interested in buying a first-time home, being a first-time home buyer and getting assistance with down payment assistance, please make sure you go to nrcdc.org and register for some of the first-time home buyer virtual workshops, as well as if you're interested in protecting your generational wealth and passing on to your heirs, please go to nrcdc.org and register to attend a lot of our virtual workshops. This virtual workshop is all about evictions, how to protect yourself, how to take care of yourself, what works, what doesn't work. And we have a great presenter. The month of service today is making sure that you are taking care of you. Whenever you're going through a stressor in your life, know that you have a team of partners that is here to assist you with whatever stressor you're going through. Many times when we're going through a stressor, when I'm talking about stressor is anything, you know, you're purchasing a new home, your taxes went up and the price of your home went up. Need to protest the price of my home. What do I do? My house got on fire. What do I do? I need to create an estate plan to protect my generational wealth and pass it on to my heirs. How do I do that? You know, my child, when they were a juvenile, conducted a crime, some kind of criminal activity. How do I expunge their criminal activity? We do that. Hey, you know, I conducted a crime, and many years ago, I have been off the records, and I need assistance expunging my criminal records. That's what the month of service is all about. We're here for whatever situations you're going through in your life. Know that you have a team of partners, and our partners are Neighborhood Recovery, the City of Houston Department of Neighborhoods, Harris County Tax Office, Harris Central Appraisal District, Houston Bar Association, Lone Star Legal Aid, Houston Volunteer Lawyers, and TSU Earl Carl Institute. Is a team of partners. We are here to help you in whatever stressor you're going through. Today, our presenter is Miss Kimberly Dykey, and she is going to be talking to you about evictions and how to protect yourself through in one way or another. How do you deal with evictions? Thanks, Miss Dykey. DK. I knew it. I said Dykey. No, it's DK. Sorry about that, Kimberly. Kimberly, could you introduce yourself and give the community a little bit information about yourself before you start? Thanks, everyone.
Hi, thank you for the introduction. My name is Kimberly DK. I'm an attorney with Lone Star Legal Aid. I am a staff attorney in our eviction right to counsel unit. A little background, Lone Star Legal Aid is a full service civil law firm. We serve about 72 Texas counties and 4 in Arkansas, and we serve our community by providing free advocacy, legal representation, and community education that ensures an equal access to justice. Some of our priorities include improving the delivery of legal services, providing advice, brief service and referrals, maintaining, enhancing, and protecting income and economic stability, seeking or maintaining safety, stability, and health or well-being, preserving housing and other housing-related needs, improving outcomes for children, and assisting populations with special vulnerabilities like the aging, disabled, the LGBTQ individuals, and a lot more. You can find us at lonestarlegal.org. for more information about Lone Star Legal Aid. Like I said, we're a full service civil law firm, so we do much more than housing. So be sure to check us out. Like I said, today I'll be talking about evictions, mainly focused on tenants, just knowing your rights, knowing what's going on, so that you can advocate for yourself. Also, for the attorneys that might be joining, I do have some references to the Texas Property Code. Evictions are handled under the 510 series in the civil procedure and the Texas Rules of Civil Procedure. But I'm going to primarily focus on kind of talking to the community. So it's going to be a little bit more informal, just so everyone knows kind of what's going on, since we are still dealing with some fallout from, you know, a loss of housing stability as a result of the pandemic. I'm going to try and share my screen. So we can start. Okay.
And you
So
your notes are showing, so you might want to display settings, go to display settings.
is it this one? Oh no.
Go up on top. To the, keep going to the left.
Oh, there we go.
Yeah, okay, that's it.
There we go.
There
Thank
it is.
you.
Yes, ma'am.
So as far as our agenda, we're going to talk about leases first. Different ways to terminate or breach of the lease, and notices to vacate, lockouts, writ of reentry, which is what a tenant can do to combat a lockout, utility shutoffs, which their remedy is a writ of restoration, withholding rent, the right to terminate your lease in certain circumstances, security deposit, and then what we all came for, forcible detainer suits, which is the legal term for evictions and appeals. First things first, is there a lease? A lease is an agreement between a landlord and a tenant that establishes the rules regarding the use and allowance of and occupancy of a dwelling. Texas allows for both verbal and written leases. However, if a lease is longer than a year, it needs to be in writing. So I encourage most leases to be in writing. They can be as long or short as you want them to be. Even if you're allowing someone to move into your room, or a sublease, anything like that, I do encourage those to be in writing, and make sure you try to get as many terms to avoid problems in the future that you can. You do have a right to a copy of your lease. So as in Houston, we have a lot of TAA, Texas Apartment Association leases, and other such general leases. So even though they feel less negotiable, but you can kind of discuss the terms. But just in case you just, get into an apartment, sign one, and don't really know everything you've agreed to, you have a right to a copy of your lease. Within 3 days of the lease being signed by all parties, the landlord must provide you with at least one complete copy of the lease. If there's more than one tenant, then the landlord must give at least a lease to one of those signed tenants, and then any other leases that are outstanding, you have to request in writing, and your landlord is required to give you one within 3 days as well. Most of the things we talk about are going to start with the lease before we even go to the law. So I definitely encourage you, even if you don't want to read it, which I don't advise, make sure you read them. You definitely want a copy, so that if you do reach out to an attorney or any other organization that might be helping you with your housing needs, they have everything, they have the terms, they know what we're up against. Also, if you are part of any type of voucher program, definitely make sure you get your lease and any addendums that you've signed. Anything that has your signature on it, make sure you get a copy of it. Especially because some apartments will also tell you that for their community rules, you have to sign something stating, I received their community rules. I don't know about you guys, but sometimes you sign the paper and it's not in your lease. So make sure you go and get those copies from your landlord or your leasing office, so you know every single thing that you've promised to follow and what you've agreed to as you move into this new property. So depending on the terms of your lease, your tenancy can be terminated by choice or because a breach has occurred. So this is not necessarily a breach, but there's a notice of lease termination or non-renewal. So after your primary term, like let's say you're there for 6 months, 1 month, 1 year, most leases contain some kind of language regarding the timeline of the termination, or if the lease will roll into a month-to-month tenancy. So after that primary term of the lease, either party can terminate the lease with proper notice. So sometimes it's 30 days, sometimes it's 60 days. If it rolls into month to month, generally it's going to be a 30-day notice of non-renewal, unless a different term is contained in the lease. But failure to leave after the termination date makes you a holdover tenant. And then once you become a holdover tenant, you're no longer lawfully allowed to be in the unit. And so therefore, that opens the door to eviction suits. Any violation of the lease terms, conditions, rules, or other provisions are also considered a breach of a lease that opens the door to an eviction proceeding. It could be something as small as leaving your trash out one too many times, and they said it has to be in the bin at 6, and you leave it out at 5, and they send you a notice. An unauthorized tenant, non-payment of rent, of course, and then repeated violations. It can be small to big, but repeated violations or any large violation of the rules can open the door to an eviction suit. And then failure to pay rent by the date stated in the lease can also is also considered a breach of the lease. So read very carefully. A lot of us are used to it's due on the 1st, late by the 4th. But some leases, depending on if you're sometimes in a single family residence, for example, might have shorter deadlines. If you lived in a bigger place, it might be the 4th, but here it's due on the 1st by midnight, get it to us, and so you definitely want to be aware of what your lease states when your rent is due. So let's say a breach has occurred or you're now a holdover tenant. The Texas Property Code requires that a notice to vacate is delivered to you in order to start that eviction process. So the notice to vacate must be in writing, and it must give at least 3 days. That's what the law states, unless the lease allows for a shorter period of time. So for example, like a Texas Association, Apartment Association lease allows for a 24-hour notice to vacate. We don't see many of them, but if that option is available, your landlord is very welcome to take that option. So you definitely want to be aware of that. And the proper delivery of the notice to vacate is an element of an eviction suit. So since that is an element of the suit, we do encourage you to take pictures or keep a copy of the note you received to show how you received it. Proper delivery includes in person or hand delivered. And if you're ever in court and hear someone say they hand delivered it, but it didn't come to you directly, like your hands or another tenant's hands or any, tenant in the house over 16, as long as if it didn't touch your hands, it has not been hand delivered. So just keep that in mind, because some landlords allege that they have delivered something in hand, but in reality, they say that because they posted it, it was hand delivered. So you definitely want to make sure you're listening carefully when you're in court. Your landlord can also send it regular mail, registered mail, or certified mail. And I wanted to know, at least for the attorneys that might be in the room, that we always say that, the safest way to do it is certified mail, right? Because then you have a tracking number and it's delivered and all that. But sometimes that tracking number can show that it was never delivered. So when someone sends something certified mail, if you're in court, make sure you double check that tracking number, because there is a presumption that if you put it in the mail, it was delivered. But in reality, certified mail, registered mail, anything that gives you a tracking number will tell you if it was actually delivered. And so you're definitely going to want to prove, if it's regular mail, yes, the presumption is a little bit harder to rebut. But when you do have a tracking number, make sure to check it, because then you can show the court, hey, they can send it all they want to, but it wasn't delivered to me. I don't have a delivery, proof of delivery. So you definitely want to keep that in mind. They can also post it to the inside of your front door. So dropping it on the counter, putting it on the wall, putting it on, even on your TV screen, or she's gonna see it for sure now. No, that does not count as proper delivery. It needs to be posted to the inside of the main entry door. And as an alternative, your landlord does have to prove this up, but your landlord can deliver the notice in an envelope affixed to the outside of your door with certain language on the front. They must prove up the circumstances, like, oh, I was scared to go inside. They have a big dog. It was locked. we've had altercations in the past. And so make sure if you hear them say they posted to the outside of the door, they need to have a reason. And then if they do post it to the outside of the door, they also have to post it, drop it in the mail by 5 o'clock on that same day. So even if you get something on your front door, make sure to keep checking your mail so that when you go to court, you can make sure you properly testify. I regularly check my mail. I have access to my mailbox. I go every day, or I have USPS informed delivery and I never saw it come in, so that, you know, you can properly testify that you never received a copy in the mail. Now, one of the things that's outside of the lease and outside of, you know, Texas state law is the CARES Act that is still in effect regarding how covered properties are required to give notice. So under the CARES Act, covered properties are required to give you a 30 days notice. Now, to qualify as a covered property, the property, you have to prove that the property is a covered housing program under VAWA, the Violence Against Women Act. So that includes like public housing, Section 8 housing, project-based, I mean, the list goes on. So what I have here is not exhaustive, though there's a lot more properties that are covered under VAWA that would require them to give a 30 days notice, but also if they have a federally backed mortgage. This includes single family homes, duplexes, mobile homes, anything like that that's covered. Now, when it comes to having a federally backed mortgage for larger properties, some of the databases are available. And since 2020, some properties might have been sold, swapped hands, released from those liens. And so you're definitely going to want to check your county's real property records, or request the information through the discovery process when you're in court. So, for example, single family homes won't show up on those databases. And so if you have someone and you just know that maybe a prior tenant or even you were on a voucher program or like a rapid rehousing program, for example, you definitely want to use the discovery process to gather that information. Hey, do you have a federally backed mortgage? You know, just so that you have that extra evidence to provide the court to show that, especially if you weren't given a 30-day notice to vacate, you want to have that evidence. Because that's the only thing outside of that, the lease and the state law that creates a new notice to vacate timeline. So what else might happen when the lease is breached? So between turning off your water or turning off your electricity, you know, locking your breaker box, for example. Now, your landlord cannot intentionally exclude you from your house, from your home or unit unless it's for bona fide repairs, construction, or an emergency, removing contents that were abandoned by a tenant, if the judicial process allows, and if you are behind on rent, the right to change the locks must be in the lease, and they have to also give you proper notice. So if your landlord gives you notice that, you know, in 5 days, we're going to lock you out, and it's in your lease, that's the only time that they're allowed to do that. And then we'll go into how to combat that in the next slide. Your landlord also cannot intentionally interrupt your utility service unless it's for bona fide repairs, construction, or emergency. And in very, very specific circumstances, like a failure to pay your electric bill to a landlord who submeters, allocates, or prorates, and proper notice and timelines are given. I think that's just in the property code, but I failed to see a situation where that applies. So essentially, your landlord can't shut off your water, they can't turn off your electricity and claim, oh, you know, you no longer have a lease because you're holding over, or you're not even paying rent, so I'm going to do that. They're not allowed to do that. They have to keep their home habitable for you. So when you've been locked out, what the lawsuit that you would file would be asking for a writ of reentry. But before that can be filed, your landlord is required to let you back into your unit once the request has been made within 2 hours of the request. It doesn't matter what time of day it is, and they cannot demand payment in exchange for the key. So let's say you've made your calls, you've made your demands, and you're still locked out. Not that you crawled in through a window, not that you've climbed in through your balcony. It has to be that you are still unable to get into your unit at all. If you've been locked out of your unit illegally, you can file a lawsuit in the precinct for your home live. This is an ex parte suit, and so you don't necessarily need to chase your landlord down and file it and serve them before the case moves forward. So you'll file the lawsuit, saying the facts under oath, and then the judge will set, and then the case will be set for hearing. Go and give your testimony. If the judge agrees that you were legally locked out, you will receive a writ of reentry. And then that writ of reentry, that is the order that you give to the constable to serve your landlord, say the judge, the courts are ordering you to let this person back in. That's what that initial lawsuit will be about. Now, let's say there's other issues and they don't let you immediately back in, and you're like, I've accumulated all of these penalties and these actual damages. I've had to contact an attorney. All that damages can be recovered in a separate suit. And so some of the damages are civil penalties of 1 month's rent plus $1,000, actual damages or expenses, court costs and reasonable attorney's fees, minus any delinquent rent or other sums. There is also an option to terminate the lease. And although your landlord, if you consistently are behind on rent, they can technically lock you out. They can only do it once per rental pay period. And so, like I said, you do have an option to terminate the lease. So if they continue to do this and you continue to file and it becomes exhausted, you can move forward with filing a separate suit and include the option to, terminate your lease without any type of penalty. When your utilities have been shut off, that lawsuit that you will file is for the writ of restoration. This lawsuit follows the same pattern. It does have to be filed in the precinct where the home lies. You don't have to serve your landlord. It's an ex parte hearing. So you just need to, put your facts in writing, file it with the court, and it'll be set for hearing. If the judge agrees that your utilities were disconnected illegally, you'll receive a writ of restoration, which is the order that then tells your landlord, that's given to the constable, served on your landlord to say, we're ordering you to restore their water, restore their lights, make your home habitable again for your tenant until, a proper judicial process has happened or you've evicted them. You can't use these self-help remedies that could really harm a vulnerable tenant. You also can be awarded damages in a separate lawsuit. You can recover actual damages, 1 month's rent plus $1,000, reasonable attorney's fees, court costs, less any delinquent rent or sums due to the landlord. An honorable mention is car towing, just for everyone's information. Your landlord cannot terminate or suspend your parking permit until the day your right to possession ends. So if you moved in and they said, provide us with your insurance, your registration, keep everything up to date, and your parking permit will be good, as long as those things still exist regarding your car, they can't just tow it off the lot saying, well, you didn't pay your rent, or we go to court in a few weeks and you no longer have permission to park here. The law says you're not allowed to do that. Your right to possession does not end until an order for the writ of possession is signed and issued. And so until the entire eviction process is done, as long as you stay in compliance, of course, with the requirements under their parking permits, they can't just tow your car. So you might have judicial remedies regarding any type of illegal towing. So I just wanted to put that out there because that seems to be happening a little bit more often as well. Now, withholding rent, don't do it yet. So yes, in certain circumstances, this might seem like a good idea, but it is a self-help remedy that is very rarely done correctly and will set you up for an eviction lawsuit. So sometimes we have clients who say, they charge me too much on my utilities, I'm double paying, or I may request 3 months in a row and they're not being repaired, or just any other instance where you feel like the only way my landlord's going to hear me is if I don't pay them. No, no, because then you're just not paying rent and your landlord can then evict you. And so if the property, so one of the ways you can withhold rent is through the repair and remedy statutes. For example, if the property is uninhabitable due to repairs that threaten the health and safety of an ordinary tenant, I would first send the request in writing, preferably through certified mail, and then contact a legal professional. There are several steps between requesting a repair and obtaining your right to withhold the rent, so it's best to contact a professional to help you get through it. Now, when it comes to repair requests, you do have to be up to date on your rent. So, if you haven't paid rent for 2 months and then all of a sudden your toilet stops working or your sink isn't working, yes, it behooves your landlord to fix it because it's also their property. However, the law allows them to kind of not, since you're behind on rent. So you definitely want to be very, very careful with how you deal with that. But also, if you are dealing with repair issues, make sure you're current on your rent, because that's what's going to give rise to all of your rights, not any, but all of your rights start, because you have to be current on rent to exercise them. So just briefly, I'm not going to go too much into all the details of it, but in certain circumstances, if you provide the required information to your landlord, you can terminate your lease and avoid certain liabilities under the lease. These are things like family violence, certain sex offenses and stalking, certain decisions related to the military, and of course, a tenant's death. If in that situation, it avoids future liability, but past due obligations like unpaid rent, damage beyond wear and tear are still recoverable by the landlord, generally against the estate, of course. But in order to terminate your lease, vacate the premises, and avoid liability, each of the statutes under these subjects will tell you what documentation you would need to provide to your landlord to move out and avoid them, avoid an eviction, avoid things being reported to your credit, etc. We talked about this a little bit last time, so I wanted to give more detailed information. But to begin, a security deposit is a separate issue. Your security deposit, your landlord may keep and deduct from the security deposit amounts for damages and charges for which the tenant is legally liable under the lease or as a breach of the lease. And then I'm trying to think of a situation where, so let's say you're holding over. If you're holding over, it's not necessarily that you owe rent and there's a issue going behind it. It's just, I don't even want to take your money because I've asked you to leave my property and now I'm moving forward with a lawsuit. Anything that's your landlord does have an obligation to refund the security deposit on or before the 30th day after the tenant surrenders the unit. Your landlord cannot retain any portion to cover normal wear and tear. But if your landlord does keep all or parts of the security deposit, they must send you a written description, an itemized list of all deductions, unless the tenant owes rent and there's no controversy concerning the amount of rent owed. So that's why I say, like in a holdover situation where we're not dealing with rent, we're just kind of dealing with, I had to use a judicial process to get you out of the unit, be sure to give your landlord a forwarding address because they can't send you money or they can't send you a list if they can't find you. But on or before the 30th day, they should have either returned it or sent you an itemized list saying, this is why, walking on the carpet is different than a broken sink, and things like that. So anything outside of normal wear and tear, they can deduct from the security deposit. But unless there's when there isn't an issue about rent or anything like that, then you should be able to get your security deposit back. Now moving on to what we're here for, evictions, which are also called forcible detainer suits that are controlled by the Texas Property Code, Chapter 24. The eviction's primary focus is to deal with the right to possession of the property. The main elements that the plaintiff landlord must prove is ownership. So the plaintiff must prove they're the owner, not the manager, not the agent, but the owner. The plaintiff listed in your complaint needs to be the owner. So if there's a title dispute or if there's anything going through probate, for example, that might be grounds to pause or to dismiss the lawsuit until ownership is properly dealt with, and then that party can come back, prove they're the owner, and move forward with the suit. They also must prove, as we said before, proper notice to vacate was given under Texas Property Code Chapter 24.005. They need to prove up, by having their testimony, having their evidence, maybe having their pictures. Susan delivered it on this day and she dropped it in the mail, or she put it inside, or she came to the office, shook your hand and gave you the notice to vacate. They have to prove all of that up. And they also have to prove that you're still in the unit. So in some situations, maybe if you vacated, definitely want to bring that to the attention of the court because I'm not there anymore. This is no longer an issue about superior right to possession. So pay attention to the date the eviction lawsuit was filed for sure. Especially if you're going in with an attorney, let them know I vacated when they asked me to, this is my proof. And now they've just filed this lawsuit, and maybe I didn't owe rent, things like that, or they claim I was holding over, but I wasn't, things like that. So that is an element that has to be proven. Non-payment of rent cases, these evictions deal primarily with possession, but the landlord can add a claim for back due rent amounts. However, the landlord can only ask for base rent. So let's say your cable is added, so you pay $1,550, but your base rent is only $1,500. They can only sue for $1,500. Late fees, past utilities, other sums due require a separate small claim suit. So make sure you also pay attention when you're served your paperwork to read it carefully. Make sure everything lines up. Another great reason to have your lease, so you make sure that the base rent that they're asking for is actually accurate. This also, I want to bring it up. It also has something to do with if you're holding over now month to month. Your landlord can't necessarily claim the month-to-month fee or the month-to-month increase unless there's proof that they notified you that the rent would increase and that your new base rent, if you decide to stay, goes to X, Y, and Z. So we do have some cases where they failed to pay February rent, but their lease expires at the end of February. Now it's March, case is heard in April. If they're going to ask for March's rent, they need to provide proof that you were notified that your rent would go up X amount or your new rent would be X amount for March in order to ask for that amount. Otherwise, they will be held to the amount that's in your original lease. So you definitely want to keep an eye out for that. You also have a right to request a jury trial. The request must be timely, generally 3 days before the date of the hearing, and a fee must be paid unless you file the inability to afford court cost forms. Now, let's say you are unsuccessful in the eviction and you want to appeal. Within 5 days of the court date, you can request an inability to afford court cost form from the clerk, fill it out and return it. If you decide not to appeal, you must vacate the unit within those 5 days or the writ of possession can be issued. The writ of possession is the order from the court that is given to the constable to let them know, hey, can you go remove this individual and their property from my unit? The constable will come and give you 24 hours notice. If you're still there when they return, they can remove you and your property on that day and just lock the door behind them. So definitely it's a fast process. You have 5 days to make a decision, and then when you file that paperwork, which I'm going to call the IFP, it doesn't make as much sense, but that's what we used to calling it, the inability to afford court cost form. Within 5 days of filing that with the court, you must make 1 month's rent payment to the court registry. This is necessary to maintain possession of the unit. So this is not an optional fee. If you do not pay it, on that 6th day, your landlord can request a writ of possession and start there. I will say you have 5 days to file the form to start the appeals process. We do encourage you to wait at least till the 5th day since you have it, because the timeline to make that 1 month's rent payment is based on when you file that paperwork. Now, after you file the paperwork, your case will be transferred downtown to the county civil court at law and assigned to a court, either 1 through 4. Some courts are having in-person hearings. Some of them are still over Zoom, or you can request them to happen over Zoom if the downtown courthouse is far away from where your home actually lies. You will receive paperwork in the mail, so check it regularly. And you don't need to file a separate answer. You will get information from the court stating that an answer is due, but you do not need to file a separate answer if you file the appeal with the IFP form. Now, if you have rental assistance pending, or you feel like you have another argument that you want to put in writing for the court to have, definitely type up an answer and you can email it, mail it to the court so that they have it and they can place it into your file. Non-payment of rent cases, those appeals that are filed with the inability to afford court cost form, monthly rent payments are due each month as due on the date that is stated in your lease. So some leases are the 1st, some leases are the 5th, 15th. Whenever that comes due, you need to make that payment into the court registry. If you don't, then your landlord, after 5 days from that date, your landlord can request an immediate writ of possession. It does have to be set for hearing. So there is a little wiggle room, but if you fail to make that payment, then your landlord can come and ask for possession back, even though your case is still pending. You can pay your landlord directly, but for better record keeping, we do suggest going downtown and making the payments yourself. When you're in county court, the case is heard de novo, which means brand new. That means anything that happened in the JP case needs to be relitigated and retried. The justice of the peace courts are not courts of record, so there's no need to tell the judge what happened last time, or she didn't say that last time, or he didn't say that last time. If he didn't say it last time, he's saying it this time. And so you just want to remember that and stay focused and pay attention to what the plaintiff landlord is doing in court, because they also have to start over and prove their case up. So that's why I said, whether they say something that they didn't say or add something or subtract something, it's a brand new case for them as well. So the landlord has to prove the case with testimony and evidence. So county court cases are more formal, the rules of evidence do apply. And so make sure you're listening and, make sure the right person is providing testimony. If the notice to vacate said it was delivered by Susan, Susan is the only one that should be testifying. If they say that they have a lease, make sure they provide a copy of the lease, things like that. So it will be a lot different than what happened in JP court. Some also might say you had a better chance of winning, with a landlord who can't provide testimony or can't provide evidence. And so it's always a risk worth taking, in my opinion. But just to know that there are more stringent rules. And so thinking about what happened in JP court or trying to let the judge know isn't always helpful. But if you are unsuccessful in county court, you have 10 days to either appeal the case or move out before the writ of possession can be requested. The cost of an appeal from county court up is usually 10 times the monthly rent due in a lump sum. So usually county court for our clients is our last bite of the apple. But it is a good way to, apply for rental assistance, get into move out agreements, get into payment plans. And so, like I said, it's definitely a risk worth taking to get that extra time and get that opportunity to cure your issues. And also just to mention about the monthly rental payments, some courts will allow for an immediate writ of possession to be issued after trial if you didn't make those monthly payments. So you'll go from having about 10 or 11 days to move out to your landlord having access to the writ of possession immediately. And so you definitely want to keep that in mind. Thank you. If anyone has any questions, I'm sorry if I went pretty fast. Feel free to ask. And then here's my other information. Attorneys, if you have questions, you can email me at kdike@lonestarlegal.org. Tenants, if you have questions, I encourage you to apply for services so that we can get you with any of our eviction right to counsel unit attorneys or even our housing unit. And you can apply for our services at www.lonestarlegal.org. Or you can call us at 713-652-0077 or toll free at 800-733-8394. Another great online resource is texaslawhelp.org. If you want things like jury demands or, templates for answers that you can file yourself, or just other information or questions, if you have some time between when you apply and when we give you a call back. Thank you. How will it be shared to work? Does anyone have any questions or want me to go over anything?
Hi, does anyone have any questions or concerns? Let's look in chat and see what kind of questions they had on chat. There are no questions in chat. Ms. Mel or anyone would like to unmute themselves to ask us a question to Ms. Kimberly? Ms. Kimberly, thank you so much. We really appreciate you. And you know what? One of the things about evictions that I've always seemed to find out, a lot of people think, and I loved how you reiterated to them to always make sure they make their payment. And a lot of people feel like, you know, hey, you know, they're not taking care of me, so I'm not going to pay my rent. And you said, make sure you always pay your rent. I don't care what happens, just keep paying your rent. And then in the process, talk to an attorney and go through that process. Because if you don't pay your rent, that's when the process starts.
Yes.
Am I correct?
Yes, you're absolutely correct. Because not paying your rent is considered a breach of the lease. And so once you breach your contract, a lot of your rights are reduced, if not completely removed. So it's most of your rights are going to begin because the contract needs to be intact as we move to enforce it. And so if you breach the lease, then obviously it's not intact. And so enforcing it, which includes enforcing your rights, will be is a lot harder, if not impossible.
And a lot of people feel like, well, you know what, if I call the complaint, the concern to 311, they're going to evict me. But the one thing, they can't retaliate against you for calling a concern, but that does not stop them from evicting you if you don't pay the rent.
Correct. Calling 311, if anything happens to you when you try to exercise your rights just as a citizen, which is what 311, for example, is, it can be viewed as retaliation, and your landlord's not allowed to retaliate against you for exercising your rights. And that could be its own separate lawsuit. But of course, like I said, you have to maintain all of your rights by saying, I'm paying my rent, I'm doing everything I need to do, I'm giving the work orders, I'm being polite, and I'm not getting anywhere. My home is inhabitable, or, you know, I'm dealing with this. So you definitely just want to make sure your contract is intact so that you can try and enforce it.
So the first thing, if you have a violation on your property and you're renting it, make sure you call 311. Keep paying the monthly rent. Do not stop paying rent. And guess what? If they evict you, once you have an attorney, let them handle the retaliation process. But guess what? They will not be able to move anyone into that apartment until they correct all the violations that a code enforcement officer noted during the inspection. So if you call 311, call in your concern, keep paying your rent. And in the process, talk to, someone from Lone Star Legal Aid and call an attorney and let them know, hey, this is what's going on. And in the process, they evict you, let the attorney handle that. You keep paying your rent, and even if they evict you, they won't be able to move anyone in until they correct all those violations. Are there any other suggestions?
Well, I would say as well, if you anticipate, like sometimes you might lose your job right after paying rent. Also reach out to Lone Star Legal Aid, look in your other communities. There are still rental assistance programs available. I do say, like I said, if you anticipate anything happening or you're 1 month behind and you're talking to your landlord and trying to work things out, contact us. We are one of the partners with Houston-Harris County Rental Assistance Program, so we can try and get a referral in there and get you in the line to possibly receive funds. I didn't have access and couldn't look it up fast enough to see what other organizational partners are working with the program, but Lone Star Legal Aid is one of them. So if you, I know Texas Rent Relief is now closed and most of their funds are becoming committed. But Houston Harris County Rental Assistance Program is still open and active. You just have to do a different process. So if you do have questions about rental assistance, please give us a call as well, so that we can either help you with an application once we review you for eligibility, of course, so that we can get you with any other partner, maybe to quicken the process up and everything like that. So yes, we still understand. We say pay your rent as if we don't understand that that's not always, feasible for some people. But there is rental assistance still available. Of course, check your community. But if you do want some of those referrals or resources, definitely you can contact us and other eviction Defense Coalition members to see, where all those organizations are, who they are, what individuals are able to put in those applications, so that we can help you to stay in your unit. Rental assistance is still available. So we say pay your rent, and we understand people fall on hard times, but rental assistance is still available. So I wanted to mention that quickly.
And Attorney DK, I love that, because a lot of times when we're going through a stressor in our life and we can't afford, you lose your job or you're behind on your rent and you're going like, oh my God, I'm about to get evicted. And you feel like you have to wait till you get evicted to contact an attorney, but you don't. I love what you just said. Call Lone Star Legal Aid, call any type of neighboring associations that can assist you. But Attorney DK, thank you so much. I love that, because we never think about the process that when we are, we're looking at our budget and we realize, oh my God, I just lost my job, or, finances are not working where they need to, that I can actively pay my rent. Well, call Lone Star Legal Aid and see if they can assist you through that process, so they can be the negotiator between you and the landlord. And that's what you need. Am I correct on that?
Yes. So you might not be able to walk away with a zero balance, but you might be able to avoid an eviction, and an eviction is going to last a lot longer than a reletting fee. So we definitely can try and negotiate move out agreements, get you the least impactful to your long-term housing. We want to get you a solution that's not going to harm you for longer than a bad situation is. Like, everyone's working hard. No one's trying to be unemployed. No one's trying to stay unemployed. But if we can reduce the impact of an eviction on your credit or an eviction on your record, it is good to start that process as early as possible. Because some places will let you out. If you can't pay next month's rent, if they're running a business, they're like, hey, you can give it back and we can give it to someone else. And yeah, it might cost you $500, $1,000, and maybe we can get you on a payment plan or something, but you don't have to, you're right, you don't have to wait until the lawsuit is filed. If you can see the writing on the wall, hit the ground running. Don't freeze, don't be overwhelmed. I say don't, right? We're human. It might happen, but
you're gonna get overwhelmed.
Push through, take a shower, clear your head, take a walk, and get on the phone. There's no shame in it. We're still, recovering from a pandemic, and we are still recovering from it. A lot of people make it seem like pandemic, it was 2020, it was 2021, but the effects are still here and they're still hurting our community. And so let us help you, at least let us advise you, let us give you a starting point, whatever we can do. That's our goal, is to just help as much as possible to create, long-term housing stability to the best of our ability.
And you know what? I love another thing that you said is we seem to forget about our long-term credit. You don't want an eviction on your credit report. That's 7 years that will stay on your credit report. So if you're going through that process and that's going to happen, it would be easier that you talk to someone from Lone Star Legal Aid, help an attorney kind of negotiate that process, even the payment plan, some kind of program that at least you're working through that process and it's not on your credit report. Yeah. Love that. Thank you. That's something that we all forget about, even during evictions. We have to still keep moving, keep going, and still got to think about our credit report.
Yes, ma'am. Absolutely.
Thank you so much. And I know there was a question about when we are having our virtual workshops. Attorney Dykey, one thing I want to remind them, and I want you to remind them, because I love what you said also before I go to this chat. You said, we all go through a stressor. We're all going through one thing or another in life. Take a step back, breathe, take a walk. Can you remind them what you just said? Because sometimes when we're going through a stressor, we forget we have to move away from that stressor to think clearly. So could you reiterate what you said? Because I thought that was wonderful.
No, I mean, like I said, we do all get stressed and frustrated, and it can hit hard. But like I said, take a shower, take a walk, call a friend, vent, yell, scream, but don't freeze. The goal is to not freeze. It's to keep moving. The sun is going to rise, the sun is going to set. So you got to move with it. Don't let too many days go by, getting down on yourself. Don't feel shame. Don't feel guilt. Just understand that life hits us all at some point or another. And so if it hits you, take a punch, get up and give us a call. If anything, we're here to advise, we're here to listen. Even if we can't help, we can set you down on the right path or give you ideas, get you questions to ask, maybe even empower you to go to your landlord, because we do understand it is also stressful to look someone in the face and say, I can't do it. But, we can help give you, a little bit of strength and support to be able to do that, so that, you can make better decisions. Sometimes you just don't even know what decisions or options you have. So it's kind of like, just get on the phone, get online, look us up, Google, like I put out, Texas Law Help, read. It's just about not staying stagnant, because tomorrow's going to come.
It always does. And when you look back a year from now, you're going to go, oh my gosh, I survived. Yeah. I'm still here, and it's much better. So I love that. Keep going. Just don't freeze. Just keep moving, keep going, and one step in front of the other. So I love that process, because you know what? We're and also know that you're not in it by yourself, and that's what the month of service is all about. You have attorneys, like Attorney DK, that is here. They're here, they're donating their time, and they care about each one of you. That, just like she said, do not freeze. I know when I was young, I went through it. I got laid off. I was just 28 years old. And of course, as a 28-year-old, you're going like, oh my God. No, but I didn't freeze. But that's how we keep going. Just remember that you have a team of partners. Just like here, we have information for you. We care. We want to make sure you're not alone. And that's what the month of service is all about. Mr. Mosley asked, how do we find out when all these virtual workshops are coming? Well, you can go to Facebook and see us on Amos Houston. You can go to YouTube. We record all our virtual workshops. You can go to YouTube and look for Amos Houston, and or you can go to NRCDC and look at the calendars, and you can register there. And all the calendars and the registration, you'll be able to see all our schedules. Or you can send us an email. My email is Myra, MAYRA Hippolyte, HYPOLITE @HoustonTX.gov. Or you can call our office at 832-394-0701. Or you can call NRCDC or any of our partners. All our partners have our schedule, and we will always be able to tell you and lead and guide you into whatever program is best for you. But we also want to remind you, this is not legal advice. All our virtual workshops are for informational basis. So we're giving you a lot of information, and none of it is legal advice. So thank you, everyone. Attorney DK, how could I ever thank you? You are always a sunshine. When it's storming outside, you always bring a lot of sunshine in. We're very grateful to you, and you're always a great presenter. So thank you so much.
Thank you very much. I'm happy to be here. It was my pleasure, for sure.
Thank you. And we really need you back. Seriously, okay. We need you back to remind us to keep going, to keep shooting for the stars. That is amazing.
Yes, ma'am. I'll be back.
Thank you, everyone.
Yep.
Bye-bye. Have a great day.
Okay.